Good afternoon. I hope it is it's still morning. Good morning. This presentation is something which is something I've worked on for a little while now. Of course, Sophie's had a version of this when we were together in Florence for a workshop. So I'd like to just begin with this illustration, which was actually in Tate Modern as we speak. It's on contemporary Africa, photographs of contemporary Africa, and sort of speaks to the language that this paper will try to cover. Can I possibly request you to the next slide? Sorry. Well, we all know who this is. He said something interesting about imagination. This paper sort of streams from that, sort of is the foundation of what this paper tries to do. And Sir Robert Jennings, the former Wheaton Professor of International Law at Cambridge, is this remarkable ideas and interpretation and imagination, and these ideas remain true as the date in 1990 as well. And the engagement of these ideas is because something which remains lacking or exists in a lacuna which needs some sort of filling. And in the direct contravention of this, you have persons like Sir Michael Wood, Casey, and also Philip Alston, who in their own respects in the different courts, or imagination of different courts, said that this is quote unquote a truly bad idea. With that sort of parallel approach to courts and also imagination, this essay seeks to explore the potential benefits and also the challenges associated with creating a court aimed to study international cultural heritage and also resolve disputes of practical nature. But the critical part of this essay, which is the foundation, is to look at this from a TWAIL perspective, because TWAIL in some sense is going to provide you the cultural diversity and the intercultural dialogue. And for this, I'm grateful to SOAS, which has furthered my studies in this respect. Of course, I'm a proud student of Professor B.S. Chimney, who is the second generation of TWAIL founding fathers and mothers. This paper will also examine the significance of the court and the protection of it in terms of sharing the cultural heritage and also providing an equitable and inclusive approach for future generations. The next slide covers a rather simple yet complex topic. You see Professor Dr. Attila Tanzi exploring, or at least trying to understand, what after all is cultural property. He goes into a deep philosophical debate discussing this and ends up having absolutely no answer, rather farther away from the truth than closer to it. You see a highlight of it over here, but Tanzi still does not address the question. You see notions exploring this very topic in the conventions that are listed over here, but in different regards and respects. But as a possible solution to these challenges, the court perhaps can answer these with an approach that it objects in its rulings and also in its opinion, as understood in the national courts or tribunals. Of course, this paper in some sense can be presented in different forums here also because of the universality and diversity within it, but the dual nature of property in itself can include physical aspects but also historic, symbolic, tangible and intangible objects which can be discussed in common markets but also in society at large. The next slide covers different topics which explore the court's dockets. Of course, this is again borrowed from the exhibition on contemporary Africa and Tate Modern in London, and it sort of is emblematic of the different characters and also the representation of challenges that the court is going to face if it is to go forward as an idea, or at least as an academic exercise, not only limited to imagination of the academy, but also of those involved in policy making. Can involve this in natural disasters, armed conflicts, activities of looting and trafficking, and also for other burning questions, and also to utilize the treaties that we had seen earlier. But the idea will not stop just there. It goes much beyond that to look at institutions and also education of culture by utilizing the means of UNESCO, but not only UNESCO, but also ICCCH, which is the International Council of Monuments and Sites. So it in some sense operationalizes these institutions and gives them an institutional framework, in some sense funneling their utility and viability. But what is important to understand, and you'll see in the next slide, is materiality. And this is of course something which I really picked up at SOAS and grateful to them for this. Because I did have Koskiniemi there, but we all know what Koskiniemi looks like. And I thought this might be a better representation. This might be a better representation of the world writ large. And materiality explains the determination of facts and evidence must have a direct bearing on the influence that it can have on decision makers. The architecture, design, layout, the spaces, and the dynamics of legal proceedings and negotiations can also influence this. And in this respect, imagine what TWAIL can do. The TWAIL can just turn the system on its head and make it look like a more intercultural and a more diverse body, not only as a fetish but also as a system of having much more viability and also perhaps potency than any other international institution dealing with issues of such importance. Of course, there is much more work done on materiality and international law in and of itself, but I couldn't really find anything which speaks directly about materiality and cultural heritage. But I'm sure there must be something which speaks to that. Of course, Koskiniemi speaks of this in a general tone, but it's interesting to look at TWAIL cultural heritage in and of themselves, because to include the aspect of materiality makes it much more of an engaging and interesting exercise. The next slide really goes to the court, what the court will actually do, and of course you've got these giants talking and spending their entire lifetime speaking about TWAIL and cultural heritage that guide these notions as cultural heritage. It's not just a resource that all people around the world share, but it emphasizes the values of preserving cultural heritage for generations to come. So this is an inter-universal duty, but also is dependent not just on one nation, but all nations together. When we do proceed to the further slides, you'll see how you just have to agree with that. So, yeah. Of course, you'll see how this has become now at least a big topic, at least in the UK as well. SOAS is almost a stone's throw away from the National Museum, and you'll see what all is going on over there. And I'll also speak about how the court can play an instrumental role in dealing with this issue as well. But as I said earlier as well, TWAIL can play an instrumental role in the court and also what the court shall attempt to do, but not only in terms of what the court rules out in its opinions and its judgments, but also the composition, the staff, the funding, the location, which is also an important issue. TWAIL in some sense is going to play a seminal role in providing an inclusive and equitable system for the protection of cultural heritage, which can be shared by all nations. That is a sort of a cursory view of this. To dive deeper into this in the next slide, we do see that coming to light. Because as we speak, England, most of the museums in England, especially the National Museum, is crumbling before our eyes. This is something that I captured when I was trying to read, not just read for this paper, but just read generally newspapers sitting in my club. But this keeps coming up again and again, and it's something which requires deeper study. Once institutions such as museums in first world countries lose their, shall we say, provenance or at least their ability to take care of these buildings, then all hell breaks loose. And Greece now wants to take these monuments back, and rightly so. But now, with the given situation, this is accelerated. But there remains the lack of an institution, or at least a framework wherein these countries can come together and negotiate. Of course, you can use track 1, track 2, track 3 diplomacy, but imagine if there were a system or an organization dealing with this specific issue with all the relevant stakeholders involved. Now imagine if this was through TWAIL, and TWAIL was at least providing the institutional framework for this. You would have a greater balance between the local and international standards. You would also have a very varied and distinct perspective on cultural heritage in and of itself. You would also have the promotion of these principles for diversity and also intercultural dialogue by recognizing the non-cultural, non-Western cultural perspectives, which makes up a larger part of these objects as well. You would also have international standards from different various stakeholders involved in this dialogue as well. But that should not be all. You will also have value of cultural heritage as a common heritage, but also the protection of it as a global concern. You would also have scholarly suggestions involved in this regard, and the court would provide a clear legal framework for resolving disputes, such as those which you see on your screens. By the way, this is very live. This is happening as we speak, so that adds to the value of this. But in the next slide, you'll see that the court, even in its nascent stage of imagination, is not without its challenges. Of course, Balakrishnan Radhagopal speaks not of cultural heritage, but of TWAIL quite powerfully, and he has these ideas which speak directly to these frameworks and the challenges that these frameworks will face by the artifacts, and he speaks about collective memory and identity, as you see on these slides. But if one was to instrumentalize his ideas and look at them in the framework of TWAIL and also cultural heritage, you would see the lack of comprehensive framework for restitution of origins, for example, is important to the conventions that you have might not be wholly sufficient to deal with this, and the institutions, organizations that do exist inadvertently perpetuate an imbalance, as their decision-making processes are often dominated by the interests of developed nations. Of course, this is covered in other presentations before mine as well. The TWAIL perspective, therefore, would call for a democratization of these institutions to ensure that developing nations can also have a meaningful voice in this complex procedure, which is at the intersection of culture, identity, sovereignty, and heritage for all persons. From this TWAIL perspective, cultural heritage code has both its drawbacks and its benefits, but the benefits wholly outweigh those drawbacks, at least in my humble opinion. The proponents of TWAIL will also argue that the code can address historical injustices and facilitate repatriation of colonial property, but that again is an issue that the court's docket can deal with. Another potential issue highlighted by the TWAIL perspective is what even constitutes cultural heritage, and that is a question which Tansy deals with, but in a very different perspective from a very different standpoint as well. But the idea still remains, and I do know that I am overshooting, so I shall now move swiftly to the conclusion, which is there on the screen, but also again returns to the British Museum, because the institution which can be addressing these issues is perhaps missing, and therefore music such as this famous and rather, shall we say, infamous one suffers. But the success of a course such as this is going to depend on its abilities to effectively address issues and also learn from the challenges of institutions and courts and tribunals such as the International Court of Justice, which has in some sense failed to deliver on its mandate given the current crisis, the war that we face, and has affected all our lives for the worst. But rather than some note, I shall end and thank you for your time. Thank you.